Good evening, Section Z. We've had an overview lecture on the estates and land and future interests, and now I wanted to do some short lectures addressing particular questions that people had on different topics. And so one of them had to do with the fee tail estate and what happens in jurisdictions that have abolished the fee tail. And so let me pull up our book to remind ourselves what the fee tail estate did at common law, and then what has happened in jurisdictions that have gotten rid of it. So remember that at common law, let's see, this is over on page 169, I think, in your book. Yeah, 169. At common law, when you had a fee tail estate, it was created by a grant to A and the heirs of his body. And the authors tell us that the fee tail descends to A's lineal descendants, the heirs of the body, generation after generation, and then it expires when the original tenant in fee tail A and all of A's lineal descendants are dead. So basically, when A's bloodline runs out, that's when the fee tail ends. At that point, the land will revert to the grantor if nothing was said, or if the grantor specifically retained a reversion, or it will go to the grantor's heirs if the grantor is no longer around, or if it was specified in the original instrument, it will go to some other branch of the family by way of a remainder interest. So that's the common law fee tail. Now, over on page 170, they tell us that today the fee tail can be created only in Delaware, Maine, Massachusetts, and Rhode Island. And they note that in these states, a fee tail tenant can convert a fee tail into a fee simple by a deed executed during life, but cannot bar the entail by will. So if you are the holder of a fee tail estate in one of those four states, as long as you act while you're still alive, you can disentail the estate and turn it into a fee simple. But if you wait until you die, then you have lost that opportunity. Now, they say that the only problem related to the fee tail that arises in modern times, for the most part, is what do you do with language in an instrument that would have created a fee tail estate at common law, but you're in a jurisdiction that has abolished the fee tail estate. And they tell us that, so that, they give us a hypothetical. Suppose that O conveys to my son A and the heirs of his body, and if A dies without issue, to my daughter B and her heirs. They tell us that there are a few states that say that A takes a life estate and A's issue take a remainder of fee simple, but that the large majority of states fall into one of two categories. So, category one. In the first category, they say, the language to A and the heirs of his body creates a fee simple in A, and any gift over on A's death without issue is void. And so in this hypothetical, to my son A and the heirs of his body, A has a fee simple, and this language, if A dies without issue, to my daughter B and her heirs, is simply ignored. B gets nothing, A instead gets the fee simple absolute. The second category, category two jurisdictions, treats that language a bit differently. It says to A and the heirs of his body creates a fee simple in A. So far we're tracking with category one. But the gift over to B, if A dies without issue, will be given effect in one circumstance. B will take the fee simple if and only if at A's death, A leaves no surviving issue, and not, as at common law, when A's whole line of issue runs out. And so the distinction they're drawing here, sometimes called a distinction between a definite failure of issue and an indefinite failure of issue. Under the common law fee tail, basically, if you had this kind of language in a grant, B's interest would become possessory at any point in the future when A's bloodline ran out. When the last of A's descendants dies, then B is entitled to possession of the estate under the common law fee tail. So the failure of issue determination is indefinite. It can happen at any point in time when A's bloodline runs out. But in category 2 jurisdictions, they modify it. And they say, we're not going to focus on an indefinite failure of issue. We're going to focus on a definite failure of issue at a particular point in time. And so they look to see whether A has issue at A's death. And if A has issue at A's death, then the interest in B is eliminated, it's void, it can never become possessory. But if at A's death, A does not have issue, then the interest in B becomes possessory. Now, note that they classify the interest in B. They say that that B's future interest is known as a divesting executory interest, which will shift the fee simple to B if A leaves no issue at his death. Why is it an executory interest? Because the only way B's interest is going to become possessory is by divesting or cutting short the fee simple that was held by A by virtue of category 2 statute. So let's take a look at a problem or two that we looked at in class to see how all of this works out in particular scenarios. And so the first problem that I think we worked through in class, O conveys Blackacre, located in Massachusetts, to A and the heirs of her body. I'm sorry, let me pull that up for you to see. Here we go. All right. Okay, problem 1. O conveys Blackacre, located in Massachusetts, to A and the heirs of her body. A dies, leaving her only child B as her sole heir. B dies without having had children, devising all her property to C. What is the state of the title? And so we're in Massachusetts. We are in a jurisdiction that still permits the creation of the common law, or of the fee tail. And so in Massachusetts, the conveyance of Blackacre to A and the heirs of her body creates a fee tail in A, and it also creates a reversion in O. Even though nothing is mentioned about the reversion, it creates a reversion under Professor Syme's formula. Remember, the vested estate that O had was a fee simple estate in Blackacre. The vested estate that O conveyed in Massachusetts was a fee tail estate, which is lower on the hierarchy of estates and therefore is an estate of a lesser quantum than the estate that O had. Since O has conveyed a vested estate of a lesser quantum than the vested estate that O had, O has retained a reversion under Professor Syme's formula. And so A has a fee tail estate, O has a reversion. Then we're told A dies, leaving her only child B as her sole heir. Since it's a fee tail estate, B then becomes entitled to possession and is the fee tail tenant, and under the original grant from O. Later, B dies without having had children, devising all her property to C. What is the state of the title? Well, at that point, when B dies without having had children, there is no descendant to take the fee tail estate from B. And so at that point, the reversion in O kicks in and the land will revert back to O, or by now maybe O's successors in interest will take it. Well, what about the fact that B tried to devise the property to C? That doesn't work if it's a fee tail. You have to act while you're still alive to disentail the estate. If you wait until you try and do it by will, you've waited too long. And so they ask, how should B have arranged her affairs to carry out her wishes? If B really wanted the property to go to C, B should have disentailed the estate during life. This could have been done by going to a lawyer's office and having a straw person transaction where B takes the fee tail estate but conveys a fee simple to the straw person that succeeds in disentailing the fee tail, and then the straw person can turn around and owning now a fee simple estate, can deed a fee simple back to B, so that B would own a fee simple estate. And a fee simple estate you can devise to somebody else, and so B would be able to devise the property to C in B's will. Now, the other problem helps us to analyze what happens in jurisdictions that have abolished the fee tail estate. And so the problem is this: O conveys Whiteacre to A and the heirs of her body, and if A dies without issue, to B and his heirs. A then makes a conveyance of Whiteacre to C and his heirs. A then marries D and has a son E. A dies intestate. A is survived by O, B, C, D, and E, who owns Whiteacre in Massachusetts. And doesn't matter if E predeceased A in Massachusetts. And so let me pull up a whiteboard just to kind of give you these transactions and events in a schematic form here, or in a simpler form. So you have the first deed where O conveys Whiteacre to A and the heirs of her body, and if A dies without issue, to B and his heirs. Then you have a second deed in which A conveys Whiteacre to C and his heirs, and then you have A dying intestate, survived by a son E. And so if you're in Massachusetts, that was the first question, O conveys Whiteacre to A and the heirs of her body. That means that O has created a fee tail in A. In this language, if A dies without issue to B and his heirs, that means that there is now a remainder in fee simple in B. Then, when the second deed is executed, the conveyance to C and his heirs succeeds in disentailing the estate, the estate of Whiteacre. And so A originally had a fee tail and a remainder in B, but when A conveys to C, it becomes a fee simple. B's interest is eliminated in Massachusetts. And so C owns the land in fee simple absolute. Doesn't matter if E survives or not in Massachusetts, just irrelevant to the problem, because the second deed succeeded in disentailing the estate and turning it into a fee simple. Now, the problem that we were looking at says, who owns Whiteacre in states that fall into categories 1 and 2 in the discussion on page 170, and what if E predeceased A in a category 1 or a category 2 jurisdiction? And so now if we go back to the whiteboard, in a category 1 jurisdiction, the deed says O conveys Whiteacre to A and the heirs of her body, and if A dies without issue, to B and his heirs. In those jurisdictions, you treat this grant to A as a grant of a fee simple absolute, and you ignore the language creating a future interest in B. B gets nothing. So A, under category 1 jurisdiction, has a fee simple absolute. Then when A turns around and conveys Whiteacre to C and his heirs, then that makes C the owner of a fee simple in the property. And it is irrelevant whether A is survived by E or not. Just doesn't matter in category 1 jurisdictions. And so C owns Whiteacre in fee simple absolute. Now, category 2 jurisdictions. When O conveys Whiteacre to A and the heirs of her body, that creates a fee simple in A, but it is a fee simple subject to an executory limitation in B, so that if A dies and doesn't have issue at the time of A's death, then B's executory interest will divest the fee simple, and B will be entitled to possession. And so at this point, we have deed 2, where A conveys Whiteacre to C and his heirs, but A conveys the estate to C, but cannot eliminate B's future interest. And so what C gets is the estate that A had, which was the fee simple subject to the executory limitation in B. And so C has a fee simple, but B still has that executory interest in a category 2 jurisdiction. And so when A dies, if A is survived by issue, then B's, at that point in time, that's the only time that we care whether A has issue or has descendants or not. But if A is survived by issue at his death, then B's future interest, the executory interest, is eliminated. And so when A dies intestate survived by a son E, then C's fee simple subject to executory limitation becomes a fee simple absolute. B's future interest disappears in a category 2 jurisdiction. Now, what if things had turned out differently and E had predeceased A, so that at A's death, A does not have surviving descendants? Then, when A dies, B's executory interest would divest the fee simple. And so C holds the fee simple subject to executory limitation, but at A's death, if A does not have issue at that point, then B would be entitled to possession and would divest C. So B would become the owner of Whiteacre in fee simple absolute. So there is what happens in jurisdictions, in most jurisdictions today, with respect to abolition of the fee tail estate.